Right, well, welcome to our seminar today, When Borrowers Default, What to Do Next. This is a joint seminar between Phil Fisher and Bellevue Mortlakes. And what we're really trying to do is, first of all, do our best to sort of steer you in the right direction in terms of what we've learned when things do go wrong, and therefore how to avoid them. But also then how best to deal with things when they go wrong. What I mean is, of course, there's default on a loan, and what do you do next? So this is a bespoke seminar for the bridging lending industry. So it's very much focused on short-term lending, and so many of the things we're going to be talking about today do relate to that. Well, we've got a stellar cast. First one accepted, of course. I'm Antony. I'm a partner at Phil Fisher. I head up the contentious property team. We have a particular specialism in relation to secured lending disputes, and in particular sort of repossessions, receivership, sales, and so on. Stewart Perry is on my right. He's also a partner at Phil Fisher. He's an insolvency partner, so all things administration, bankruptcy, liquidation, and so on. And he's going to be talking to us about that, and indeed trying to avoid all of the above. On my left is Hinesh Varsani, who's a partner at Bellevue Mortlakes. He wears two hats really. He's a receiver. He's not just a receiver, he's the very best receiver in the business, and also runs a valuation practice doing mortgage valuations. Hinesh and I have worked together for about 10 years, and he really is absolutely phenomenally good. Hands-on, gets the job done, and gets the results. So it's a cool trick. I need to tell the truth. So what we're gonna do today is I'm going to start off by looking at what to look out for when you're lending, how to sort of avoid some of the issues, and also how to deal with some of the issues when they do arise. And a lot of the issues that do crop up, some of them are unavoidable. Your borrowers just got themselves into financial difficulty. There's not a lot you can do about that. But what you can do is make life a lot easier for yourself in a situation that then arises. Then Stu's going to deal with some insolvency issues, talk through the various forms of insolvency arrangement, and tell a couple of war stories. And then finally, last but very much not least, is Hinesh is going to give the receiver's view life and give the benefit of his considerable experience in terms of, again, what to do, what not to do, some tips, slips, and some more stories. So let's crack on. Let's start with the lending documents themselves. Now, I promise I'm not going to go through the provisions of the lending documents that you know better than I do, but there are things that I see as a litigator, and my team sees, and a couple of them here today, which are sort of themes that make life more difficult for us as litigators. Events of default. It's amazing how often the event of default is not that clear. You really do need to make your events of default as clear as possible, so there's absolutely no argument about the fact that an event of default has happened, and that's a trigger for you to be able to take action in relation to a default. Clarity when interest kicks in, when default interest kicks in. Again, it's amazing how often it's not clear. It doesn't really matter whether default interest kicks in when the event of default happens or some other day, as long as it's clear. I think the assumption is, oh, it must be when there's an event of default. And it's amazing how often we've seen, actually, it's not really. It's not, certainly not clear. So make sure you're clear on that. Big point, and my team will smile and nod vigorously when I say this. Can you please, please, please always have an address for service in the UK? Because when we come and do our job, and there's address for service in Dubai, we have to serve in accordance with Dubai law in order for it to be effective service. Guatemala. Does anyone in this room know what the Guatemalan mode of service is? I haven't got a clue either. It's one of the few places I've never served. But it's amazingly how difficult it is to serve in some jurisdictions. It can take weeks. So, and that also holds up the whole process. Address of service in the UK, please. Guarantors. Again, it's an obvious point. But if you've got a guarantor who's got their assets overseas, it's going to be very difficult and very slow and very time consuming to get hold of them if when you come to sell the property, there's not enough money, there's not enough equity in the property.
So the other thing is you always get like statements of assets and things like that to go with your background. We'll take a guarantee from this person. If it's 2 million of property in UAE, that doesn't help us enforce, right? It needs to be this property with this address, and even that actually we've got one now where it's, you know, this is the address in Dubai, and our local lawyers are going, we're not really sure where that is. That could be one of like 5 different areas, and so actually when you are doing this, actually work out what the asset is, because otherwise it's not really much more than them going the checks in the post. It's that kind of useful. So do actually get that. Be done.
Yeah, no, absolutely. Stu is going to explain why you need a floating charge as well as a fixed charge, so I'll leave that to him to do in a few minutes' time. And also clarity around when you can appoint a receiver. Generally documentation is quite clear on this, but again, just be very, very clear when you're able to do that under the LPA and so on.
So I'm going to keep bugging you.
Yeah, go for it.
I'm saying the odd point. The thing that we do like frequently is you want to appoint a receiver, you just want to get on and do it, yeah, because they take control and protect your asset, which is great. Usually the document says it's enforceable on an event of default happening or something like that. Sometimes it says on demand and, right? So that then means you need to have an event of default and demanded, and then you can appoint. So you go, okay, so what are the notice provisions? The notice provision, you've got to post it. Okay, and it's deemed service 2 days after posting. Okay, so now we can't just like with no notice get Hinesh in there to secure the property.
Or you could give notice in Guatemala, and then
yeah, and then you've got
probably 3 months time.
So then they've got 2 days notice to just like do whatever they want to mess with your asset. So always try and make it, you know, it's enforceable on an event of default. No demand is necessary. You can just go straight to appointing Hinesh and boom, he's in and he's got it. You don't really want to give people prior notice if you're taking action.
There's been many cases where I've often said to Luke and Antony and the litigation side, give 72 hours notice, because it's fundamental that we go in there quickly. And the reasons for going in there quickly is because sometimes borrowers, by the fact that they've been given a very demand notice, they're given 7 days to then think about, oh, be a clever borrower and take possession of this property. And when a borrower takes possession, even though your loan docs will say you're not allowed to live there, they do. And by giving them short notice of 72 hours or even shorter, it allows us to quickly go in there, put in our security team, and avoid the whole process of going for possession, which could be 3 to 6 months, depending on what court you're in.
Yeah, and that's, I mean, Hinesh makes a really good point, which is even if it's contrary to the contract, or even it being an unregulated loan that someone's living there, they're still the Criminal Law Act and the Protection from Eviction Act still applies. So you still need a court order if they're actually living there, even if they're living there contrary to the terms of the contract. Clear terms on costs and other expenses. You don't rely on court costs and that sort of thing. You want clear terms that you can recover the costs of default, whether that's legal fees, receivers' fees, etc. And I the only thing I'm going to say is clearing all your minds, which is register of overseas entities. Obviously, always bear that in mind, which I'm sure is hotwired into your systems. So, what about other things that can be done? That's the documentation. What other things can you do pre-lending that can help you? Now, you appoint valuers for two reasons. One, because you want to see whether your loan to value ratio conforms with your lending criteria, and that if there is a default, you can get it. You can get your money back. And two, because if your valuer gets it wrong, you can sue him or her. That's bluntly why you get it. Now, what I'm going to tell you now is all of the things that you should be, or some of the things you should be doing, in order to make sure that if the valuer does get it wrong, the valuer's not got loopholes to jump through to stop you bringing a successful claim against them. So, first of all, sounds too obvious to say, but clear instructions on the valuation as to what's been valued. In other words, if it's a leasehold property, he or she's not valuing the freehold, obviously, valuing the leasehold. If there are 3 layers of leasehold, and which layer are you lending against? And therefore, that's the most sort of blatantly obvious thing. But as I say, clear instructions at the outset. That's it. When you get the valuation back and there are caveats in there, read them. And they'll be in small print, but read them. Because if the valuer says, well, actually, I haven't been able to get into the property because of such and such, therefore I don't know, blah, blah, blah. Now, that may be very, very important to you. You may really need to know what's going on in the property, in which case you say, okay, we'll get you access, go back in and have a look. Just be careful of those, the small print. The other small print to be careful of is the assumptions. I've assumed that there's planning permission, I've assumed the building regulations, approval of got blah, 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 blah. Well, that's an unsafe assumption for you to make, because if you haven't got planning permission and the planning authority required to be pulled down, then your security's gone, or at least a big chunk of it. So be careful of that. The other thing to do is and again, I'm sure you will do this, is that specialist property requires specialist values. A hotel value is valued differently from a development site, from a shop, from an industrial site, or a residential property. So particularly for things like hotels, it's a completely different valuation. Make sure you get the specialist valuation. So, yeah, go for it. Yeah.
So being a valuer myself, I completely agree with Anthony in terms of the assumptions, and I'd love to say the assumptions are the mother of all. I'm sure you know the section, but it's actually true. Where when you're a valuer and you've got, for example, a house connected to 2 flats, and it hasn't got planning permission, but the valuer assumes it has, it makes a massive difference on the actual recovery. So assumptions just shouldn't be relied upon. And I think to overcome a lot of the issues when you're comparing the valuation report, that all-important report title being prepared by legal advisors and then put in front of the valuer to ensure that the valuer looks at the report title, compares against his own assumptions in the valuation report is quite key. Sums up a lot of the issues.
Yeah, the next thing I want to cover off is indemnity insurance. Typically, there's no building regulations approval, so something like that. And in this is not nothing to do with valuations. This is the borrower saying, oh, by the way, I know it hasn't got planning permission, but here's indemnity insurance. Now, the indemnity insurance in most cases will cover a situation where the local authority decide to come in and enforce. That's it. It doesn't cover the dent in value of the property, probably doesn't, almost certainly doesn't. It doesn't cover a situation where the property falls down because it hasn't been built properly, because no one's inspected it for building regulations. Probably doesn't cover that either. So be careful with indemnity insurances. They're not the panacea of all evil. They just cover what they say they cover, and read the small print carefully when it's offered. It's amazing how often borrowers will say, or potential borrowers will say, you know, it's fine because look at the small print. Priority agreements fairly self-evidently will, if you're the second charge, third charge, will say, okay, we're the first charge, we want to go first in terms of foreclosing, in terms of taking possession. Well, that's kind of okay, but the best priority agreements give the first charge holder a period of time to do that. And if they don't do it, then allow you to. Again, it's incredible how often you see priority agreements that simply preclude the second charge holder from doing so, unless the first charge holder says, yes, you can. So what do? You're stuck. Your first charge holder's not doing anything, you're stuck. Don't agree those. It's, you know, before you lend, you want to make sure that, all right, you give them first go, but if they don't do it, then there's a default X number of days you can. Just very quickly, a few other things. We've talked about planning permission and building regulations approval. Listed buildings, Hinesh, I'm sure you'll come in on this. Listed building approval, listed buildings are problematic, as you probably know, particularly as people tend to do stuff with them they shouldn't, and the local authority can come back and many years later and say put it all back as it was before. That's incredibly costly. So be careful about that.
And anyone any solicitor that's acting for someone that's buying a listed building is going to go through the listed buildings with a fine-tooth comb. And often what we find is solicitors being pedantic, they do pick up on things, and then it does have an impact on realisation. So just got to be ultra careful about listed buildings.
Yeah, and then just as you appoint a valuer, so if the valuer gets it wrong, you can see the value, you appoint a solicitor for exactly the same reason. So do make sure you're getting proper answers in the report on title to the questions you need answers to. If there's a restriction registered on the title, what does that mean? How does that impact on me if I need to take action if there's a default? That's what you need to know. And if you're not being told that, then make sure your lawyers do tell you what it means. Because again, always have in mind, I know we see it from the sort of the back end when things go wrong, but I think you should see it from that perspective as well when you're lending. What happens if it goes wrong? Will I be able to get possession back? Will I be able to sell cleanly? Will I be able to sell it to a decent price? I just want to spend just a few minutes talking about leaseholds, because leaseholds have their own special issues. Self-evidently, freehold, you've got it, yeah, the borrower's got it for forever. Leasehold, not so much. They've got it for the period of years that it says on the lease, unless they can extend by some statutory provision. Long leases, traditionally, on residential property, you are looking for sort of 75 years plus, central London and sort of Mayfair and so on. Yeah, valued in a slightly different way. But that's still, I think, a sort of a pretty solid rule of thumb. You know, those, but actually there are a few things to look out for in respect to that. Shorter leases tend not to have any value. 5-10-year lease will probably not have any value unless it's a particularly amazing location, and particularly if it's for, I say, commercial rent. So I think the other thing to look out for with leaseholds is subtenancies. So, in fact, even freeholds, you're looking out for subtenancies. In other words, have you got a right to possession? Now, if it's an AST, that's fine, as long as it's not too long. But if it's, and you can probably sell it subject to the AST in many situations. But if it's got a 5-year lease granted or a 10-year lease, you've got a problem. You can't get possession of it. So look out for subtenancies, look out for tenancies in relation to freehold land as well. And then you do need to focus, or get your lawyers to focus on the lease terms. And here are a few things that impact on value. when you're taking your security as a leasehold property. If the rent is high, it's going to be less valuable than a property where the rent is. And if the rent is, even on a long lease, the rent is a sort of market rent, it's probably going to have no value. So watch out for that. Large amounts of expenditure that need to be expended at the beginning of the lease, or indeed during the lease, will tend to devalue a property. Consent to charge, a massive one. The landlord needs to consent to charge, and you don't get that consent, then you don't have an enforceable charge. So that is a major issue. That's something you need to look at hard. Assignment, alienation provisions, pretty boring provision in a lease. It's not, because if you take possession of that property and you've got to get landlord's consent, that's all going to take time. Even if it's not to be unreasonably withheld, the landlord's going to want to know who you're selling it to in order to decide whether they're going to consent to that. That is quite an important provision for you. Restricted user. If you can only use a country house as a hotel, and you can't use it as a residential property or for anything else for that matter, that is going to impact on the value, almost certainly. And unless it's literally the only use that anyone would ever use it for. Yeah, that's almost certainly there, isn't it, in most situations.
I think the one bit of advice I'd add as a receiver is when it's sent to assign, if you are in the market of lending in prime London, I think it's very important that the solicitor that you're using to do your loan is au fait with how transactions actually work in London. So you've got various nuances amongst the Crown Estate and Grosvenor. The Crown Estate by far will want to inspect the building before you actually assign. They'll send out JLL nowadays to see if the property is as per the licenses to alter, etc. If the license to alter, if there's any variances in the license to alter that was granted previously to the borrower, and you turn up, or they turn up, and it's a completely different shape or different look, they will, on their license to assign, impose conditions where when you have to sell as a receiver or even the lender, they will want the incoming buyer to rectify all the issues that were incorrect. So just be careful of the various nuances of various freeholders within one.
Yeah, absolutely. And then finally, just the final few points for me. You quite rightly, you start talking to your borrower when they default. That's absolutely fine. Obviously, there's a dialogue, and you may agree concessions with the borrower, and that's fine too. Just a couple of things. Once you've agreed a concession, get an email back. Email's fine. Back to the borrower, setting out what you've agreed, making it clear that what you've agreed doesn't constitute a variation of a facility agreement, and that should be stated in terms. And also, always allow yourself the opportunity to terminate that arrangement whenever you want, for whatever reason. And the reason for that is if something else comes in and you find the borrower's not been entirely straightforward, you may want to go, right, actually, okay, my agreement was on one basis. I now find the factual matrix is different, therefore I want to terminate it. And also be careful about default interest. Quite often, what are you doing with default interest? Are you suspending it? Are you giving them a rent holiday? A default interest holiday, should I say? Or what's happening with default interest? If they then default, can we go back and recover the default interest for the period of forbearance? Just be clear what you're agreeing. Whatever you're agreeing, it's fine, but just make sure it's clear. And also be clear about the positional costs. So in other words, if you're getting your lawyers involved, find out how much it's costing and make sure that you pick up those costs as part of the deal. So I think be really clear and make sure you always confirm in writing. And that makes everyone's job easier if it then goes wrong and the deal is not
Onto Stu. Hello. So I'm an insolvency person, so I'm just going to tell you some brief things. So basically, a glossary, so that when you go away from this and someone says, "Oh, my borrower has gone into whatever," you have some idea what it is. I'm also going to tell you about the different types of security and why I think it's important you get the most you can from everyone all the time, even if you think that's not going to give me any more money. So this is a little thing saying companies and LLBs are pretty much the same. They can give fixed or floating security over land or chattels, as in non-land assets. People and old-style partnerships can give fixed charges over land. They can't really give a floating charge unless it's a farmer. And charges over chattel assets and bills of sale are really hard to do, so you don't really do them. Why are the different sorts of charges important? So, a fixed charge. Hinesh is appointed as receiver of fixed charge. What does he do? He sells the property, he takes out his fees of dealing with that and gives you everything else. So you get most of the money from any fixed charge realisation, okay? So a fixed charge gets you money. You look at what a floating charge does. So a floating charge is a charge that just floats over all of the company's assets, and then on an insolvency it kind of goes down and sits on everything that happens to be there at that time, okay? And what happens then is, usually, an insolvency practitioner sells all the floating charge assets as well, takes all of his expenses out, not just of dealing with those floating charge assets, but of dealing with the entire insolvency, and has to pay preferential creditors there, which are employees and now the Crown for PAYE and NIC and other things. Then the prescribed part comes out for unsecured creditors, and then the floating charge gets paid money. So in fact, there are loads of stuff that comes out from floating charge realisations first. So you would always want to hope that your fixed charge asset gets you paid out in full, because if you're relying on your floating charge asset to get you paid as well, you're quite far down, and hopefully, you don't really want to be there to rely on that. But it might get you something, right? If you're out with if the property is sold and you've not been out before and there are some extra assets there, then this might get you some money. So it's a floating charge is a nice to have to get your money back, but it's a really good thing when it comes to power. Okay. So what I'm going to do now is look at some insolvency processes so you can understand what they are. Again, this is part of the glossary bit. Okay. So, a Law of Property Act or fixed charge receiver. Let's imagine you're given a fixed charge over a property or shares or something like that. You're going to appoint a receiver over that asset. And unlike other insolvency processes, this isn't in fact an insolvency process. It's an enforcement of security, right? And the receiver is appointed over that particular asset, not that company. So if you've got like a development site or something like that and you appoint a receiver over it, that's cool, but you can do all the other things that the company might have, like the machinery that's being used to develop the site and things like that. You can use them to develop the site. The powers are usually, the statutory powers are limited in the Law of Property Act, but your charges will extend then to allow the receiver to do pretty much anything he wants. The good thing about a receiver is that they don't have to be a licensed insolvency practitioner. They don't have all the obligations that IPs do when, like to do statutory reporting to the government on the director's conduct or anything like that. And they are usually surveyors, and they're usually over property. So you've got the expert that knows how to deal with that property immediately. Whereas sometimes if you appoint a licensed insolvency practitioner as administrator, who then sells the property, he'll appoint a surveyor anyway to deal with this. You kind of double up a bit on that case. So they tend to be cheaper. Better value for money is a better than cheaper. And usually leads to the terminal decline of the borrower, right? Because you've taken his asset and you're going to sell it. So that's what the receiver does. The receiver is appointed over the asset, sells it, gives you loads of money back, because that's what the fixed charge is all about. Administration. You'll have heard about this in the news a lot. So an administrator can be appointed by someone with a qualifying floating charge, or the directors, or the court with a court application. Court applications are very rare. Usually the directors do it. And the administrators have this objective to try and rescue the company I've managed that 3 times in 20 years, so it doesn't really happen. What usually you do is you sell the business as a going concern on all of its assets, right? And the third one is just to repay secured creditors. That's the final objective. But what it does when you appoint an administrator, it creates a moratorium. It stops anyone doing anything. So it means that you are not able to enforce your security rights. And to the extent the receiver has been appointed, they can request or demand the receiver leaves office. So if you don't have a floating charge, you've only got a fixed charge, then what happens is you appoint a receiver and go, right, I've now taken control, that's good. And the company goes, actually, we're going to appoint administrators. So then they appoint an administrator who, if you don't have a floating charge, you have no control over who they are. And then they say to your receiver, too long, you're out of here now. And you lose control. So the good thing about having a floating charge, it means you can grab control. If they try and appoint, they have to give you notice first. So it allows you to remain in control of realisations and getting the most value you can get back to you. Back onto the glossary. Company voluntary arrangements, schemes and restructuring plans. These are ways that companies can try and get, can agree with all of their creditors that those creditors will get paid less than they're entitled to. But it's in the best interest of everyone, usually because a shareholder's going to dump loads of money in. And they're only willing to do that if all creditors take, say, 50p for every pound they're due. If you get these are rare, they shouldn't affect secure creditors. CVAs don't affect secure creditors, but if you get one through, get your lawyer on the job to look at it to make sure they're not trying to do something weird to mess you around. Liquidation and strike off for that matter. The company, a liquidation is like a fire sale. Liquidator goes in, sell things, all contracts are ended. If the company has any value, you would expect it to go into administration first, because that's the way of getting most value. So if it's gone into liquidation, it kind of make you go, whoa, what's going on here? This is a bit scary. Let's get the receiver in over our asset and work out what on earth is going on. Now I've got through the boring bit. I can tell you one more story. Okay. Okay. So this is the okay. So I've got 2 to tell you about. So this is the physical reality. Okay? We've got the dotted road. We've got private road. It's a farm, right? Farmers, and what they've done is they've created a company. And they've got that company has created a biodigester. And that biodigester does all like the chicken entrails, everything else like that, put in it. And then they all bubble away and rot, and that creates heat and gas, and that makes power, right? So all good. Our lender is lending money to the company that has this site with this biodigester on. And what they're doing is they're building it. It's going to come good, and everything's like, once it's like performing well, all the science is working right, they'll refi with someone that's doing it on a longer term thing. This is what practical reality is. This is what the legal titles are. The farmer, the farmer's mate, the company, and the company as well. Okay. And that's what the right of way looks like. So this is the legal right of way. Not quite what the physical reality is. So we get appointed by the bank. Okay, and the bank says to us, okay, this borrower isn't playing ball anymore. We need to enforce. They're a bit sly. I come from farming country, so I'm allowed to say he's a farmer. Farmers are all a bit sly, right? So what has he done? So what all our client has done is taken a fixed charge over this title. Okay, that causes some issues for us because what they've done is this title here is also owned by the company.
Stu, do you want to shout out the number for those online?
Oh, sorry, for those online. Number 3 is a little parcel of land that is also owned by the company as well as Title 4. And there's this weird thing in property law called unity of title, isn't it? Where 2 properties next to each other are owned by the same people. You don't have rights against each other anymore. Okay? So we've been appointed receiver over here. We're not allowed to get over this piece of land. Because, again, you remember, receivers are appointed over an asset, not over the company. Okay? So what we ended up having to do here is we appointed a receiver over that, and then we couldn't sell it because it was landlocked. We have no way of getting in and out because we can't sell this piece of land as well. So what we had to do was apply to court, spend a lot of money and a lot more time to get an administrator appointed, because an administrator could sell that piece of land and that piece of land, and then we could get value back to the bank. So the purpose of this is to say it's really good to have both because it gives you options. I've got one more because this is another fun one. Okay, so this is another biodigester plant, but what this one does is it works. It's a farm with loads of cows.
Stewart's not biodigestible.
Yeah, they're just fun because they're all done by farmers, right? So they mess around and do strange things. So what the farmers did is they had a massive biodigester plant. It was like painted like a cow, it was all white with like black splodges on. And then they had all the cow excrement put in the biodigester. It would bubble away and bubble away and bubble away. When it stopped bubbling, it was like super concentrated cow shit. It was then pumped to this lagoon, which was the top of a hill. It was the size of 2 football pitches, 2 meters deep, and the borrower, right? You've got a farm about as big as this wall, and the farmer gave this bit leased to a company, and the sensible lender lent to this company and took a guarantee from the farmer and secured that guarantee over the property. Okay. So we go in, we appoint administrators over the main company. Administrators then look at it and go, with their health and safety people, what's this thing at the top of the hill? And they get a report back very quickly that says danger of death. It looks like it hasn't been made very well. If it rains hard, that's probably going to burst its back, and you're going to get literally a sea of concentrated cow shit going down this hill. And there are people that live down the hill, and they're going, whoop, 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 danger, danger. So we're just going, we need out of this as quickly as we possibly can. So the administrators sold anything that would move and then surrendered the lease. So they could just go, right, we're out, right? And then what it is, it's a farm owned by Bob. They appoint a receiver over that land, right? And the receiver sells all of the land, but for the lagoon of shit and a path to the road. And we make an application to court and go, on notice to the Environment Agency, we think we can do this. We're going to do this. You're right with that. And the Environment Agency set up and go, ooh, but that's like a £10 million clean-up obligation there. You can't do that, can you? We just don't think that's very nice. And the court went, yeah, but they can do it, can't they? And yeah, but it's not very nice though, is it? It's not very, yeah, but you can. But so then we sold it, and we got loads of value for the bank because the bank had firstly taken a fixed and floating charge over the company's assets and got a guarantee and put the receiver in because it was secure. And that allowed the receiver to do this sneaky nice bit of leaving the massive pool of concentrated cash behind and selling the rest of it for a few million quid.
How much did you sell the pile of shit for then?
We left it with the farmer. So we just said we exited the receivership and then just said to the farmer, there you go, mate. That's what you get left. The main takeaway from my part of this is when things go wrong, the more security you have, and different types of security, everyone you can think of, the more options you've got, and therefore the more money you can get back. There you go.
Next.
Have you ever done really big piles?
What do we do, receivers? I kind of think where the conductors in disorganized orchestra. We sit there, we review matters past, present, and future. The past is largely taken by lenders and their professional advisors. So Antony's touched on valuations and things to look out for when you're actually entering into a loan, or your legal advisor needs to look out for when entering into a loan. Fundamentally, we're initially for the fund And when we initially sort of instructed, we look at redemption amount, valuation, and the legal due diligence just before you enter into the loan. There's nice things like cross-collateral securities. So I've been involved in, this was right when lockdown happened, and you weren't allowed to go out of your house. Estate agents were not allowed to move. But a lender on that particular occasion, they lent to company A, they lent to company B. Both had common directors and shareholders. And what the lender didn't do was sort of look and say, can I cross-collateralize this? I.e., I've lent separately to A, separately to B, but what happens if the receiver gets involved and does a receivership on A, there's a shortfall on A, can the shortfall be recovered by B? So that was something I learned very early on. If you are lending to common directors and shareholders, look at your loan docs and see if you're able to cross-collateralize, because you are lending to different companies, not the actual individual directors and shareholders. Upon reviewing everything, most receivers will be able to quickly identify a suitable strategy. I think as a receiver, we are in the middle of borrowers. We have a duty to borrowers to achieve best price. We're often talking to their financial and legal advisors. We're dealing with our appointers, our solicitors. If you're dealing with snotty freeholders in London, you're often dealing with Grosvenor and Crown Estate, who they themselves don't understand what a receiver actually does. I'm often having to tell Crown Estate or Grosvenor, this is the role of the receiver. They still don't understand it, and they use solicitors who still don't understand it, but we as a receiver are involved. So for us, we sit in the middle, and we reflect. We try to push the right buttons. By pushing the right buttons, I like to. The best way to achieve a redemption is via the borrower refinancing, and that doesn't happen by chance. The receivers, their legal advisors sit and think about strategies. We often talk quite late at night to say how are we going to push this particular borrower or their mortgage broker to get things done a lot quicker.
And I think that's the crucial thing, it's the lateral thinking. It's not, right, I've got a property, my job is to sell it, job done. It's not about that, because that's often not the best result for a lender. Someone like Hinesh will think laterally and think, right, okay, what other potential solutions here? Or even actually, what can I do with the property that's actually going to maximise the value? And that's what any good receiver will do.
I think for us, it's about helping the borrower, let them refinance. If there's a lender that's going to take them out, take my appointer out, I'm happy to do so. That person that might be, the borrower might be refinanced to another lender. That lender might obtain additional security from the borrower, and on that basis, they can make the deal work and allow the refinance to happen. IPs and administrators, they can fulfill the role of a fixed charge receiver. Stewart touched on it before. Are they best placed to recover certain types of assets? I tend not to agree. I think a lot of IPs come from an accounting background. They're suitable for realising businesses, going concerns, partially built developments, and other asset classes. They play a huge role in realisation, but lenders need to be aware of the distinct differences of skill set between what an IP and a receiver does, i.e. a surveyor who's acting as a receiver. Surveyors were often we're from a property background, we understand how to realise property, and surveyors or receivers who come from a valuation background, they're more in tune with what the actual the finance world is doing. So when I'm a receiver, I'm often there. I often know brokers who are trying to refinance borrowers out. I know good brokers, and I come across bad brokers, and sometimes when it's a person that you're familiar with, you're more inclined to believe what the broker is saying, as long as we're providing evidence. We also know as valuers about who the borrower is going to refinance to. We often, as a valuer, deal with valuations for an array of lenders. So we kind of know what loan to values are, what lenders have got an appetite for certain things, and we're able to sniff if the borrower's prospects of refinances are actually true or not. And that's often key to establish the what, when, who, and whys, especially when you're dealing with borrowers who are always going to say, I'm going to get out of this, I'm going to refinance. Are you? Are you really? Who are you going to? Let's have proof. Time-saving measures for receivers. A lot of these are sort of common sense. Occupant's name, number, and email address. We often issues finding out who's living in securities, if tenanted, an up-to-date tenancy agreement. We often, lenders don't have up-to-date tenancy agreements. Gary can supply a full list of what you actually need when you're in a position where you have to sell property. And when I say a full list of documents for a tenancy agreement, I mean certain instances where if you do have to go to auction for an investment property, where there's a residential property, there's an AST, you want to be able to fulfill a buyer that this tenant is genuine, is paying rent, or she's paying rent, and if they're not paying rent, is the document or the right documentation in place to actually get possession? So the tenant handbook, where tenants, when issued an AST, will have to sign a document to say that they've received a gas safe certificate, etc. Those things help when it goes to section 21.
Yeah, to regulation.
Yeah. And that's what you're trying to do. We're trying to sell an asset in the best possible light. So the information that we have is critical in order to achieve the best value. Otherwise, you just end up saying tenancy unknown, haven't got a copy of their AST. What's that going to do to anybody? It's going to put them off. Any opportunities with the loan documents to snoop around, even if it means by changing locks. Luke found a very good provision within the loan document. Anthony, do you remember the?
Yeah, I do. Yeah.
So we were appointed on a quite large security in London, and we gathered that the borrower, who was an international borrower, wasn't there, even though she claimed to be living within the property as an owner-occupier. Contrary to the loan documents, she shouldn't be living there. We had surveillance as a receiver for their 2 weeks, various times, and at that point, there was a caretaker who would monitor the property. So our security themselves were confused as to who's living there or not. So I said, I need to get into this property. I don't believe the borrower's there. The borrower is calling me off an international number. She can't be there. So Luke found a provision in the loan document which said that the lender can have a surveyor, inspect their security. I could go in there as a receiver, but the lender could send a surveyor. That surveyor was from my firm, surveying inspectors, and the next day managed to change locks. We took possession the very next day. That saved a long time on possession. If you're second charge lenders, very important for you to have on file the most recent redemption statement. That helps receivers and their legal advisors contact the first charge if it all goes wrong to say, we are receivers, this is the account number, your first charge would get it, but give us an up-to-date redemption and let us crack on the second charge. Receivers will redeem you and you just sit there until you get money. If lending to a company have personal guarantees, service addresses we've touched upon, also asset liabilities, receivers will look at that. If they think the redemption amount or the redemption looks tight, so we will start looking at that at a certain point in time in readiness to hand over to solicitors if it does go wrong. Loan documents, application forms should be reviewed by solicitors in order for them to also consider the exit. The right values, we've touched upon that before. When you're entering for a loan, it's important to have correct values. Look at the assumptions, as I said before, the assumptions are the mother of all. We all know that the same.
Also, the right valuers and agents when you come to sell as well. So you can demonstrate that you've got 2-3 valuations, selling it for a proper value, and that you're using good agents who carry out long marketing process, or protects you against accusations of underselling.
If you're lending against new build, who are the warranty providers? Are they credible? Are they in the name of the borrower or the builder? And if they're in the name of the builder, it's no good if we're receivers on new build properties, because we can't use those when we're selling an asset. They need to be assigned. Prime landlords, I've touched upon. Gary, who often does all of my transaction work in Fisher, he's best placed to guide on how to deal with different landowners. The most basic things as a receiver, again, service charge and ground rent demands. They are of no use when entering into a loan, but just the mere fact of having the service charge and ground rent demand on file, that information is quite key to a valuer, to a receiver, because it just enables us to go through the motions a lot quicker. Often when we're dealing with landowners, as I've mentioned before, they do not understand what a receiver does. They just look at the land registry and say, it's owned by X. Who are you? So by having the ground rent and service charge, it will enable Phil Fisher or solicitors to write to the landowner and say, your obligation is to a receiver, provide all the future ground rents to the receiver, and we'll be in touch. And that helps a lot, especially when you're conducting receiverships on mansion blocks where there's porters and 24-hour security, etc. It saves a lot of time. Searches, the latest sets of searches, keep them on file, hand them over to the receiver and his solicitors. I know a lot of lenders don't do searches, but if you have, then it will mean that transactional colleagues will have a head start. As a receiver, I often work backwards in terms of I ask Gary, how am I going to sell this? What are the problems? What do you see, Gary? When I speak to agents or buyers, what are they going to try and use against us to try and chip the price. And if I'm armed with that information ahead of any sale, it puts us in a better negotiation position when I do come to sell it later on down the line. Maintaining relationships with valuers and solicitors and brokers that we use to enter into a loan. We've had a number of occasions where solicitors who've done the loan element missed a few things. And it's always nice to maintain good relationships with those solicitors, because later on down the line, yes, they might have missed a few things. We're all humans, we make mistakes, but at least they can rectify it, as opposed to the new set of solicitors that are acting for us as receivers, rectifying an issue that could quite easily be resolved by the person that got you into this loan. Possession, it's critical, and that's often the most time-consuming bit. So anything you can do to look at your loan documents and have declarations to say that the borrower, their family, the relatives, their mum, their dad, is not living in the property, it all helps down later on down the line. Be careful when you are trying to, as lenders, trying to manage a defaulting position. The minute you start collecting rents, it's going to put you in a bad position. So you should really take advice before you actually start to collect any rents, because it could later on down the line have an adverse implication on the actual value of the security.
You've really essentially got to decide, are you going to take on that tenancy, which you may not be subject to, and if you accept rents, you do, or are you going to take clean of the tenancy, which you may be able to do, but not if you start accepting rent. So you've got to make that decision very early on. Do you want the cash, or do you want possession? In most instances, you probably want possession.
I've before this commercial, sorry, the coronavirus act and all that sort of stuff came into place. There was instances where I was dealing with properties in Park Royal, and there were rents on industrial units that were being paid that were extortionate, and the lender said, "Should we start collecting rent?" I said, "Don't do it. Just don't do it." I got appointed, and on that basis that they didn't collect the rents, we turned around to the tenants and said, "You haven't got consent to have this lease in place. We don't know who you are. We haven't collected your rents. Excuse my French. Do one." We shut the shutters, and off it went. Yes, tenants jump up and down, get that, but they have no right to be there. Lender did not give consent. For us, I think engaging with solicitors and receivers at an early stage makes a huge difference. Even our presence on pre-appointment advice makes a huge difference, because I know that a lot of lenders are dealing with borrowers, and you have a relationship with borrowers, but the fact that there's solicitors and receivers in the background looking at this and being CC'd into emails makes a difference.
And the other thing as well, as I said earlier, well-drafted lending documents will allow you to recover those sorts of costs. And if the tenant, if the borrower is in default, then you're probably going to be reasonable, instructing solicitors, and indeed starting to talk to receivers. That's probably in most cases recoverable costs. I think that concludes what you were going to say. It concludes what we were all going to say. I think looking at the time, if we've got a couple of minutes for questions, I think we've been exactly an hour. We started 5 minutes late and we finished at 5 past. Any questions?
And the most important question is, why is it so hot in here? Where's the cold drink? And the cold drinks are just down there with a lovely view over the river. So even if you can't stay for long, have a look at the view first.
Yeah, but any very quick questions before we conclude?
If there are any questions from the people watching, I don't know how we can hear them, so just email us.
No,
We'll tell you after.
Jets will tell us.
Yeah.
No questions. No questions
Well, I
online.
was going to ask them about your example, your first example, but it's probably easier if we do it over a piece because I need to plan. Be quite
Okay.
understand your point.
Okay, cool. Yeah.
Is it possible to get a copy of this?
Yes, absolutely. So we will email these out to you following this. This it'll probably be first thing tomorrow morning. So you'll each get a copy of the slides. So hopefully they'll be useful. Okay, well then I think any questions. If I haven't got any questions online, we're here. There's a drink just down the corridor. We'll point you in the right direction for those people who are here. Perhaps not for those people online. And thank you very much for coming. Hopefully some of that's been useful, and hopefully it's all been useful. But it's great to see you. Thank you very much for all those joining online. Thank you very much for all those people who have come to see us in person. Great to see such a good turnout, and thank you very much.
Thanks.